Thank you for joining us for our Dying Without a Will series. My name is Megan. This video presentation is about the probate process.
What is probate? Well, probate is a court process that passes or transfers probate property. Now, probate property is any property that does not have a beneficiary designation, a payable in death designation, or isn't owned jointly. Okay, most people in here probably own real estate, and the real estate is owned jointly with your spouse. So when you pass away, it passes to your spouse automatically. In that situation, that's not probate property. But once your spouse passes away and it passes to your kids, it becomes probate property. Okay? And it would have to go through probate. Probate also provides for payment of outstanding debts. If you do not have a last will and testament, Minnesota law will determine who gets your estate assets and not yourself. Okay? It's based on Minnesota law. And now, an example of how this affects people. Again, most of you guys probably own your real estate as joint tenants. But if for some reason you own the real estate or any kind of your homestead real estate, with your spouse as tenants in common, or if just it's in your spouse's name, and you were to pass away without a will or a trust, what would happen is your spouse would get a life estate in the property. Okay, so they can live there during their whole life, which sounds good. But then the remainder interest would go to your children. The problem with that is that if you ever wanted to sell the property, you wanted to mortgage the property, you wanted to do anything with that property at all, you would have to get your kids' permission to do that. And not only do you have to get their permission to do that, but they have to actually sign on to the deed, okay? And they're entitled to a portion of those proceeds. And that's based on Minnesota law. That's an example of how Minnesota law isn't necessarily the best way to go. We've seen this happen time and time again, and it obviously creates big issues and big problems, passing it through to your heirs and beneficiaries, because a lot of times you intend it to go to your spouse, and that's what everybody thought was going to happen. But in a situation where, again, it's owned by one spouse and it passes through, it's not necessarily what happens. Upon your death, it automatically passes to your spouse. As tenant in common, it doesn't automatically pass to your spouse. You actually have to go through the probate process to pass the property to your heirs. Both names are on it, but it's the way that it's arranged. It's actually on the deed itself. It would say to you and your spouse as joint tenants. If it doesn't have that magic word, joint tenants, in there, then you own the property's tenants in common. And like I said, most of the time, I would say about 90% of the time, you're going to own it as joint tenants. Because people are going to say, well, what do you want? And when you buy the property, the title company typically asks, how do you want to receive it? And they try to do the best job they can to explain what happens if one of you guys dies, but how you want to hold it. But I've seen it, again, way too often, where you're holding the property's tenants in common. So it would be well worth just checking on it, just seeing. Again, probate it's a court process, and it takes between 7 and 12 months to complete. Now, the reason it takes so long is, number one, is that you actually have to petition court, so that takes 30, 60 days. In addition, probate has to stay open for a minimum of 4 months. So for creditors, after publication, it's 4 months for creditors to say, I have a claim against the estate and I want to file against the estate. And then after the 4 months, you have to go through and file final count, inventory, and all these other things to close the estate. And that's the reason it takes so long. In addition, the probate process is an expensive process. So it's not a cheap process, and it's a long process. It's not a fun process. We kind of talked a little bit about probate property. And property that's titled solely in your name is an example of probate property. Property held by you as tenants in common. Property owned by you that does not have a title. And then an asset that has no beneficiary designation. These are this is probate property. All right, so probate process. The way it goes is, first of all, The personal representative petitions court to be appointed, and the court will appoint somebody. The personal representative is responsible to identify your property, care and invest your probate property, determine the value, investigate validity of claims, provide payment of valid debts, distribute your remaining property, and then provide a final account to court. That's your personal representative's job. They usually appoint a family member to act as the personal representative. Now, I have an example right now that we're working through an issue. We have a family. There were 4 children, and they were from separate, their dad passed away, separate moms. And the kids are divided based on who the mom is. Go figure. And we have daughters that they're gainfully employed. They actually do very well. They have their own house, they own all that stuff. And you have other kids that are living off dad, living in dad's houses, using dad's assets, all that stuff. Okay, they're really just kind of enjoying a good life because they don't have to do nothing. Because dad's done this. No will in place. Dad passes away, completely unexpectedly. Now, you have a fight, who's going to be a personal representative? The court, in its infinite wisdom, said, we're going to put personal representatives in place. That's the best thing we can do. We'll make sure that these people work together. Sounds good, right? One from each mom? Well, in the meantime, these people don't talk at all. They're supposed to get values on property. You're supposed to sell properties. And then, son, one of the siblings, decides to drink a little bit. Okay, maybe a lot. Decides to take dad's car for a spin. Runs into a fence, drags the fence down the road, past a police car. Police car pulls him over because he's dragging the fence down the road. And now they're not only is the car damaged, but they're forfeiting the car under Minnesota DUI law. This could have been prevented very easily by putting a will in place and saying this is the people I want to be appointed as personal representative. Because bottom line is I know that son's going to do, the handwriting was on the wall from the get-go. And dad should have known that. It just didn't take place. So now we are spending thousands, well I'm not, but they are spending thousands and thousands of dollars on attorneys. It's really no fun. It's really no fun to see the kids fight. And the kids get into this bash and you see this death happen, and I've seen this time and time again. It changes people. And now this family that they used to be able to communicate, they used to be able to talk. Immediately after dad's death, they got together and they spoke about this. They agreed to these things. And it just kind of all fell apart because that stuff wasn't put in place. And if dad put a will together and said, I want this one person to act as my personal representative, it would have avoided a lot of these problems from happening because it would allow one child to go through and move forward with this process.